Court does call the case of People versus Jillian Carey.
On behalf of people, Your Honor. Good afternoon, Your Honor.
All right. We're here on the motion, your motion for discovery, to compel discovery.
All right, pause right here. This is a classic discovery fight. Defense is invoking MCR 6.201, Michigan's rule that forces prosecutors to turn over evidence that could help the defendant. Sounds routine, but trust me, this is about to get heated fast.
Yes, Your Honor. Should I begin?
Go ahead.
Yes, Your Honor. I moved for discovery of potentially exculpatory material under MCR 6.201. I made that request in July. The prosecution had 21 days to comply and did not provide anything or any response until very recently. Last night I received his response to my motion. I filed a reply today, Your Honor. I'm not sure if you had a chance to.
I read everything, counsel. So
I know I do. So if you read everything, then you know what I'm asking for. And I'm asking for discovery of communications between the alleged victim, who's a fellow by the name of Will Hathaway, outgoing Scioto Township supervisor, and communications between he and members of the prosecution team, which include officers.
how do I know these exist?
Sorry, how do you know? Well, I believe they exist. I know for a fact that there are emails after the discovery was produced to me between the key detective in this case, his name is Detective Parvis. He's the quote unquote computer expert in the case. And
Well, he's not quote unquote a computer expert. He's extremely skilled in what he does.
I'm sorry, I didn't
So
mean
go
to
ahead.
confuse him, but I don't know what his title is. I was just saying computer expert. But he has been having communications with Will Hathaway, who's the complaining victim, and also with members of the IT department of Scioto Township. There have been emails, there's written communications between witnesses. And
How do you know that?
because I learned that from my client because Mr. Hathaway was talking about emailing with this gentleman. I believe they exist, and Detective Parvis also came to the township and met with Mr. Hathaway, trying to follow up on the information that we provided to the prosecutor, showing why this case is completely a non-case, that there was no crime that occurred in this case, not even a crime, let alone my client committing a crime.
This is a bold moment. Defense isn't just saying my client didn't do it. They're saying no crime existed at all. That's a nuclear argument in court, and judges expect receipts, not beliefs.
It wasn't a crime. An old email and an old meeting request were sent when my client clicked on that.
I've read that, counsel. I'm just trying to figure out how I know these things exist.
You don't, Your Honor. You don't know until you look. And when I asked the prosecutor for this information, he said, on information and belief, I don't think they exist. That is not the proper response from the prosecutor, Your Honor, and you know that. The prosecutor's response should be, I checked with the sheriff's department, or I looked at these materials, or they don't exist. All I got was,
Well, what information and belief? Why you may not like the response, but the response is his information would have had to come from somewhere. So you're talking what words he was using as opposed to anything else.
no, I don't think so. Respectfully.
Well, I do.
Okay, well, do you understand what I'm asking for?
Not really, because I don't know what documents you're saying exist that the prosecutor hasn't turned over.
Okay, I'm saying that there are emails for sure between Detective Parvis and Will Hathaway. He's a complaining victim, and I would ask for those emails to start. But I would ask for any written communications between any witnesses and the sheriff's department and the prosecutor's office.
Okay, so the only way you know that there are emails between Mr. Hathaway and Detective Parvis are because Mr. Hathaway said so?
If I have a moment, I can tell you exactly. Can you give me 1 second?
Sure.
So, Your Honor, the way we know that they exist is because Will Hathaway forwarded those emails that he was having with the detective to another member of Scioto Township, another employee. That's how I know.
Here's the turning point. The defense finally explains how they know the emails exist. Secondhand forwarding. Legally? That's shaky. Strategically? This is where credibility starts getting tested.
So where's that employee?
You asked me for testimony from a witness?
I asked you a question.
Where is,
Where is the employee that says they got the emails?
Well, they're not at work now, it's past 4 o'clock and we didn't know we needed to have them here.
So this employee received, I'm presuming, on their personal email or on the Scioto Township email?
Scioto Township, Your Honor.
So my question becomes, why would your client, if they exist, not have access to those through their IT department?
Anything to me.
My client has not been able to get access to that. And I don't think she's requested
Well,
access.
counsel, do you have have you tried to get them?
Have I tried to get them? Me?
Yeah.
I've done a FOIA for communications at the township, but this is stuff that happened more recently from when I did the FOIA. And it's, Your Honor, with all due respect, this is exactly what the prosecutor should be doing, is finding out, are there communications between my witnesses and my police officers that are.
No, with all due respect, what you will do is you will answer my question.
I'll answer your
Have
question.
you attempted to try to get them?
No. I mean, I did by filing this motion. How else am I going to get discovery, Your Honor? I guess I'm confused by your question. Have I attempted?
Shouldn't be confused by my question. Look, the prosecutor is not required to do what is really part of defense's job. Certainly, they must supply evidence that they have and comply with any reasonable request. But you come here to me today, and I don't know that these things that you're requesting, whether they exist or not. And the only way that you know that they exist is because somebody has said that these were sent to somebody at Scioto Township, and that it's between Detective Parvis, presumably, and Scioto Township. So my question is, on that end, why don't, if they exist, when did this happen? You're saying it's recent, but when?
I can get you a date. Within the last 2 weeks. But it's not just that, Judge.
If I may.
I think I'm still arguing.
No, I'm just trying to clear up the point here.
No. We don't do it that way here.
Thank you.
Just for a bit of context, Your Honor, if I may. Mr. Boloda provided me with some information from some computer person Dave retained. And it had to do with a meeting invite that went out around the same time that this email went out. That information was emailed to me, and I don't know, because I'm not a computer expert, what it is that this information entails. I forwarded that information to Detective Parvis, and I've spoken with Detective Parvis. He's attempting to, I believe the term is the header information that is retained on the servers at Scioto Township. He's basically trying to vet that information, Your Honor. And so that has happened in the last few weeks, and perhaps in attempting to vet that information, Detective Parvis has been communicating with Scioto Township. I have no specific knowledge of that. I haven't been provided anything, but it wouldn't shock me that Detective Parvis is following up because I asked him to follow up. He told me that at some point he's going to provide a report to me. I don't have any sort of report, and I don't have any update for the court I'm only saying that in as much as I am aware that Detective Parvez has been communicating with the IT department of Scioto Township over the last couple of weeks in response to information provided to me.
Okay, well, that's a big piece that's left out. So you provided something to the prosecutor's office
Yes,
that your expert provided to you.
yes,
And then from that, the prosecutor's office then sends that information to try to figure it out. So how do I get to there? And so that hasn't been completed yet.
I've not had an update or any reports. My understanding is the IT individual from Scioto Township, the primary person is out on some sort of leave. And the other information was that obviously with an election forthcoming, the current IT person has a lot going on. So there's a delay, I think, in getting that raw data to Detective Parvez so that he can, validate whether this is or is not true based on the defense expert.
So, I mean, is there anything in that that's not true?
no. And
So why am I here? If you gave them information and they're trying to unlock that information that you've given them, why am I here on a motion to compel that information where it's not been done yet?
because that's not what I'm not asking for a follow-up report. I'm asking for communications, Your Honor, and not just with Detective Parvez and the IT person, but most importantly between Will Hathaway and members of
Yeah, but doesn't that come from isn't that the subject matter of the meeting invite, or am I reading that wrong?
what is the subject? The meeting invite was for a meeting that happened 11 months or longer before. So it was an old meeting. That's why I say that this case was just essentially an IT issue. It had nothing to do with any individual action, anything. And that's why this case is in this courtroom before you on this matter, because there is no evidence. And that's why I wanted to spend some time talking about the case to show you that the principal witness is Will Hathaway. He is a political rival of my client. My client was running for the position that he now holds for the time being, supervisor of Scioto Township. And he was a long time political rival. So he's the one pushing this prosecution, Your Honor. He's the victim. He went to the sheriff and he's pushing this. So all of his communications with the prosecutor's office and with the sheriff, I believe I'm entitled to. And at the very least, I'm entitled to the court to make an in-camera determination as to whether there's anything exculpatory if they exist.
If they exist.
I know. This whole thing could be solved if the prosecutor had said in his response, I asked, and there aren't any. I asked the sheriff, and there aren't any emails. There aren't any texts. That's all he has to do, but he didn't say that. He said, on information and belief, I don't know about any. And that's just not enough. That's not enough.
So you wanted to use specific words?
Well, I mean, the Supreme Court said that he has a duty to investigate material within the possession of the police. And he's telling me that he doesn't think there is any, but he doesn't say that he even checked.
Okay, so let's presume this, counsel. You make the request. Mr. Childers goes to the police department. Police department says we don't have any. He then has to respond to you. He doesn't know that because he can't say they absolutely don't. He can only tell you what he's been told. So if that's all that he can say, he would have to say on information and belief based upon, which is really going to be based upon conversations he's having, I don't have anything.
Understood. And I've been on that side, and all I would say is, look, I asked, and they don't have it. Okay? And maybe he did ask. I'd love to hear him say that he asked. But what I've heard from him, and I met with the prosecutor, Your Honor, is I heard from him that Will Hathaway made a contradictory statement to him, telling the prosecutor that he himself did not write the email that was sent, the untimely email. He had said to
Counsel,
other
I
people that he did
can't,
write it.
I
So want
can't
this
get
to be-
into evidence on the case. You're asking me, I mean, you keep throwing this stuff out there. I don't know if that's the evidence or it's not the evidence. I'm here on your motion, which is quite frankly improper in the way that you drafted this motion.
How so?
But because you lay out all of these things that, and quite frankly, counsel, made certain accusations against people in some conspiratorial sense that turned out not to be true. For example, you specifically stated that Patricia Reiser authorized the complaint. I went to the complaint, I looked at the complaint, she did not. And then that was before I got the response from the people, because I didn't know for sure.
I didn't say that. I said that she worked there and that was her job, and that's factually accurate. And it,
No, then you misled the court, because you made it seem, as the one's reading it, as though she's the one that's authorizing it. Don't tell me, counsel, what my impression of it was. And I think you intentionally tried to mislead me. I'm going to let you know that,
I did not.
because that didn't happen.
That's good. I'm glad it didn't. It shouldn't happen. It shouldn't happen, but it also shouldn't happen.
You know what? You better sit down,
Design a motion.
because you're going to learn.
This recess is not procedural, it's disciplinary. When a judge says, check yourself, that's courtroom code for you're losing control of the narrative.
Real quick how to address this court. I don't play that way. I'm going to take a recess. You check yourself, and then I'll come back. Court's in recess. Counsel, you've indicated emails between Hathaway and Parvis. What else are you looking for?
Thank you, Your Honor. And let me just apologize to the court. I know you took a recess, and I want to say I'm sorry. I did not mean to disrespect the court in any way. I apologize if my arguments came across that way. I would say that it's probably due to my extreme belief that my client is absolutely innocent. I apologize for my zealousness, making me feel that I was being disrespectful. I very much apologize. Other things besides that, Your Honor, the communications between Will Hathaway himself and members of the prosecution team, including Parvis and Deputy Phillips, who's the officer in charge of the case. So that's what I'm asking for, communications. And I don't need to say anything more. I'll rely on my brief.
Well, no, I do have a question. How do I know these exist?
You don't. You don't. I only know what I've heard and what I've reported to the court. And what I was asking is for the prosecutor just to check. And maybe I misread his response. Maybe he was saying information belief means he checked. I just want to know if he looked and if there's nothing, then I'll.
Did you ask?
I asked for him and he said he wouldn't provide them. So they weren't discoverable during our.
Mr. Childers?
Yeah, and the problem, this is now like the third time in this hearing, as well as multiple instances in the pleadings. The defense is misrepresenting statements that I've made to the point where I don't feel comfortable speaking with the attorney absent being on the record or in writing. We've had phone conversations and somehow the subject of those phone conversations shows up in the pleadings, inconsistent with what was actually said. There was a statement in the pleadings that the fact that the defendant passes private polygraph, I should act upon it, even though I specifically told the defense attorney that the only way we would do anything on the case is if she passed the police polygraph, because as this court well knows, that's standard procedure. That offer still stands, and Ms. Carey wants to avail herself to a police polygraph. Not only would I welcome that, I think that a result on that could be highly dispositive in a case like this. It's my understanding that she's not willing to do that. That's her right. That's fine. As far as my communication with respect to emails, the statement that I was responding to that I would not turn over would be internal emails in our office among the attorneys, because clearly that's work product and that would not be turned over. But in fact, in that conversation, what I told defense counsel was, candidly, there are no emails. I've never emailed with Mr. Hathaway. If I had, it wouldn't necessarily be discoverable. It could easily be work product, but those emails.
This is massive. The prosecutor goes fully on record. No emails exist, no contact with the alleged victim, and a clear promise. If anything turns up, it will be disclosed. That directly undercuts the entire motion.
Don't exist. I've never emailed with him. I didn't communicate with Chris Reiser in our office. Obviously, I wouldn't communicate with John Reiser, and to insinuate others is frankly, when I read the pleading, I had a thought to communicate with the bar regarding the ethics of the pleadings and the communications in this case. I am not aware of any email correspondence between Detective Parvez and Will Hathaway, and I'm not in possession of. Obviously, if there's a report that Detective Parvez produces, and that report insinuates or includes those emails, those will be turned over. If the report reads as if there was email correspondence between Detective Parvez and Mr. Hathaway, I will ask Detective Parvez, please attach those emails in your report, and I will tender them. The court is well aware of the work product that I do and the ethics that I hold and how the fact that in this case, the allegations that this is some grand conspiracy is insane to me. It's truly insane. I've practiced in this court for a very long time, and I've never had an attorney accuse me of what has happened in his pleadings, and I take great offense to it. I will continue, as I always do, to follow my constitutional obligations and the obligations in the Michigan court rules with respect to discovery. But I can't create discovery where no discovery exists.
I will respond to that by saying, number one, I did not do anything unethical in when I filed, and I agree that I should have no more conversation.
Counsel, let me just say, when I read your motion to compel discovery, and you were giving this background information, I'm not going to opine on whether or not it's ethical. I think you have made certain allegations against people that if I were to call you to task to say that that actually happened, I think you might be hard pressed to do so. The very fact that people with the same last name exist in an office doesn't mean that they had anything to do with it. In fact, typically, certainly as it would be between Patricia Reiser and John Reiser, I'll just say this, maybe what you're saying happened. Maybe. But the ethics of these individuals, if one's going to question them, then you better bring it. And not just try to float out that somebody did this or did that. Because, and I'll make it very clear, Miss Patricia Reiser has practiced in front of me for years. Known her for years. Her ethics are beyond reproach. The fact that I can tell you this and almost would bet my barker that if something came across her desk and it had to do with Scioto Township, and she knows that her husband is involved in Scioto Township, she'd have nothing to do with it. She would stop, it would go someplace else, she would forget about it and never have a conversation. That's who she is, that's how she's practiced, that is everything about her. So when I'm reading this, counsel, I'm going to tell you I have serious doubts when it starts that way. But things can happen. And that's why I went to the file before we got here to figure out who had it. She didn't have it. Her name's not on it. And I don't think it's fair to make accusations about people, offices, how they operate, without being able to substantiate it. You tell a story that somehow or another somebody, I mean, after getting done reading this, here's what I've got to believe. I got to believe somehow in Scioto Township, there is somebody who went to the sheriff's department, made some complaint that the sheriff's department then, without any basis whatsoever, then put together a report that they submitted to the prosecutor's office based upon their investigation, and that it didn't have, that there was no basis there to do anything, that then it got into the prosecutor's office, and the prosecutor's office then said, well, we don't see anything here, but we're going to make this happen. Wouldn't happen here. And that's really how your document reads. I go ahead.
I was gonna say, I apologize that it reads that way. You have to, if you would just see it from my perspective, I'm coming into this case, I don't know Miss Reiser, I don't know any of the players, all I know is what I'm seeing, and I see a woman who was part of essentially just an IT issue, and she ends up getting charged. I've talked,
But counsel,
it makes no sense.
and maybe it doesn't make any sense. Maybe somebody made a bad decision in terms of their discretionary call. That's totally different from saying you shouldn't have done this to that there is this intentional thing to happen to charge your client. I'm having a hard time believing that. So while you may have absolute faith and belief in your client, which you should, that doesn't mean we create a conspiracy as to why something happened. Somebody may have made a bad call. Okay.
I 100% agree. I only wanted to give you the players and what their roles were. That's all I was trying to do, where people were and why it seems fishy to me. This case seems fishy, Judge, and I want to know if there's any shenanigans. I want to know if there's shenanigans in emails or texts between witness Hathaway and the sheriff. That's what I want to know. And if they don't exist, then the prosecutor can just say they don't exist. I guess that's what he's saying. So I'll take his position as, unless he wants to change it, as being, I've checked with the sheriff and these exculpatory documents don't exist. If that's the case, fine, so be it. That's the record and I will say nothing more. I appreciate the court's time today. And again, I do not mean to be disrespectful in any way.
So, because I'm not going to go through this again.
I don't want
Because, no, listen to me. You know, counsel, sometimes I want to just take attorneys back and just have them understand that in the privilege to practice law in the state, you need to be respectful of the process and the people. And you have to do it in a way that doesn't practice in a way that doesn't jeopardize your credibility. And I think people don't do that. And sometimes they don't do it with just the words they use. You know, Mr. Childers gives his response to your motion. I can tell you, I appreciate, I guess, Mr. Childers' discipline and how he responded, because I think if certain accusations had been made against me in my office, mine would have been a little bit more fiery than that. But that's just me. Do you have a copy of your reply?
I sure do. Would you like to? May I approach? Oh,
No, I've got a copy right here.
oh, sorry.
I've got a copy right here. I want you to just follow along with me.
Absolutely, sure.
In your reply, that it's their 11th hour filing of its response to your motion to compel. Really?
Yeah, it was filed last night or yesterday. I filed it weeks ago.
What's the need to say that? I'm going to know exactly when it's filed. What's the purpose behind that, counsel? Really? To say that somehow they were dilatory in what they needed to do and just sort of threw that in? I mean, really, what's the purpose in that? Then go to the next
Can
paragraph.
I just answer your question?
Go
The
ahead,
purpose
if
is
there
to
is
explain
one.
Why this was short and done in the last minute.
Counsel, I know when everything comes in. So, and then you make the pejorative statement in the next paragraph, counsel. That the people shrug off their constitutional responsibility to locate and produce potential Brady material. Did they really do that?
Yes,
Then counsel, why do we get to the point today after this hearing? What have they shrugged off? List it to me. No. If you're gonna stick by that statement, list it to me.
Yes. It's constitutional duty, and I'll quote.
I know Brady upside down and backwards.
All right.
So you don't need to quote it to me.
But they shrugged it off because they said, I don't know about anything. They didn't check. They didn't look. They didn't become educated, as far as I know. Maybe they did. And I'd like to know that. If that happened, then they didn't shrug it off. But right now it looks like they did. Looks like they shrugged it off.
Even now?
Mr. Childers has still not said that he checked. He still has not said that he.
You have got to be kidding me, counsel. Even now.
Did he check for emails? Can I just ask him?
But even now, counsel, you sat down. Mr. Childers gave his response about what he would do. You sat down and you said, okay. I then read something that you wrote, and you're still maintaining that somehow or another they're not abiding by the Constitution in some way of jeopardizing your client's rights. I'm going to tell you, and I will assure you, counsel, in my court, your client's rights will be protected. And quite frankly, that is in regard to any attorney or whatever. Even if the attorney's not doing their job, I'm going to do my job and make sure her rights are protected. So but after we get done with all of that, you still are sitting here saying that he's shrugging off his constitutional obligation, counsel.
You asked, I thought your question was, why did I put it in there? Right now, if he's checking, then I'm not saying that. I do not still think that. Is that your question? I'm sorry. I thought you were asking me why I wrote that. So.
Yeah, well, I still am curious as to why you wrote it, because it's not true.
I disagree with you. I'm sorry.
Show me where it's true.
I just disagree.
No, show me where it's true. If you want to disagree with, you know what, counsel? The way I work, if you're going to say it, you're going to be called upon to put up or shut up. Show me where it's not true. Now.
The prosecutor did not educate himself as required by constitutional law by going to the finding out if there were emails. I know there are emails. I know they exist. And for him to say they don't exist, it's not true. So there's emails. So I know that's not true.
He's not in possession of any emails. He doesn't know that counsel, I've asked you what emails exist. Your emails or your knowledge of these emails
Now, what?
supposedly come through basically 3 levels of hearsay as I count. And so the thing is, when I ask you, tell me what you want. When was it? What are they not giving you? You can't give me anything.
Your Honor, I know what I know, and I explained how I knew it, and that's all I know. Okay, so I was asking for a general.
Counsel, that's not the way I practice in my courtroom. If you come here, you better be ready to answer my questions and put forth what you're saying. I don't operate on speculation of something. If you're telling me that the people have something in their possession or have access to that may be exculpatory to your client, certainly, but even if it's inculpatory and they haven't given it to you, you need to lay that out to me on something other than speculation about whether or not something exists. That's the way I work.
How would I know? How would I know if it exists? If I don't ask.
And you just can't make the accusation, counsel, that they're hiding something.
I'm just asking. I wasn't saying they're hiding anything. Asking for the information.
No,
Sorry if I-
your whole motion is an accusation, counsel.
I don't read it that way. I'm sorry. It is an accusation. No, it's an accusation
That they shrugged off their constitutional duties to produce certain evidence that they don't have, and you don't know if they have it or not. I mean,
I'm asking for it. I'm just trying to compel it. If you don't compel it, then I'm the one never.
what are we going to compel?
I would ask for an order saying, turn over any if they exist, that are exculpatory. That's all. If they don't.
Counsel, that is about as useful as turn over every unicorn in your possession. Because I don't know that they have either one. I mean, that's not a basis of a motion to compel, counsel. That's not how you practice. If you, and by the way, counsel, some of this you can FOIA, you can subpoena it. But you also have to do your job. And if they're not turning over something and you truly believe that they're not turning over something, then fine, come before the court. But be prepared to tell me what they haven't given you. Don't give me some conspiracy story. Don't give me all of these things. Don't say because something's politically charged one way or another that all of a sudden makes it something, because that makes no sense to me. You tell me what you want. If you think they're not giving you a direct answer to exactly what it is, then yeah, come here, I'll ask them. And they know I'm going to ask them. And then you can go from there. But you can't just throw everything up in the air saying they're not doing something when in fact that's not true. And here's the other part, counsel. The other part to this is, until Mr. Childers said so, because I didn't see it in any of the documents, this all starts from something you gave them. I mean, so you give them something, they fulfill their duty and obligation to try to follow up on it. And while they're in the midst of doing that, you do this. Crazy. That makes no sense to me. Why wouldn't you just wait? Find out if there's a report. If there's references to communication, then certainly one might be able to get those communications. But I'm not one that believes in a lot of conspiracies. But counsel, In as much as I want to believe, or you want to believe, that the prosecutor's office is running around trying to figure out how in the heck can I get at Miss Carey, why wouldn't I believe that you're giving them that document from the expert, having them go on what may be a fishing expedition, and then filing this motion is somehow and or another your attempt to try to make them look bad? Why wouldn't I think that that's the conspiracy you entered into?
If you knew my reputation, like you apparently know Miss Reiser, you would know that I wasn't trying to pull it.
Maybe then I operate on the presumption that people are acting in good faith until they show me something different. And that's why I don't go there to think that it's some kind of setup. I think you just met.
And here's the judge's final lesson. Courts don't run on speculation or conspiracy theories. They run on evidence. Filing early, without proof, didn't just fail, it backfired.
Mess this one up, counsel. I think you messed it up, and I think what you need to do is you need to make sure to wait for that. See what it says. The court will give you the time to analyze it, look it through. If there's a reference to some communication, then there's something there that says that it happened. But I don't have anything now. What day is this set for? The motion to compel discovery is denied. Mr. Childers, please prepare an order to that effect. Submit it to the court. As to the probable cause here, where do we need to go from here?
I think we should probably set it for another PCC and a probable cause hearing.
How much time did you need? I mean,
Well, I kind of understood from Mr. Childers that they're still analyzing the motion. Now we need to say.
I don't think that's what he said. I think what he said is he's going to be analyzing information and they'll be looking at it all the time.
Judge, are you going to be handling the probable cause hearing?
I will be handling the probable cause hearing. And whether or not it stays with me for exam is yet to be determined.
Okay, thank you.
Probable cause conference in this matter will be adjourned to November 26, 2024 at, is that, pardon?
Those are at 9 a.m.
9 a.m.